So our first question today is, when a lawyer sells a practice to another firm, who is entitled to the uncollected receivables for previously billed work? And that question is asked by Elizabeth Zelinka of Encoraco. So Elizabeth, thanks so much for your question. When it comes to negotiating the unbilled services, that is the WIP, right? The work in progress, when a firm is in the process of selling its practice, we're showing here that what we find is that there are 6 meetings needed to sell a law practice generally. During the due diligence phase, which is the second of the 6 meetings, is when the selling law firm is typically sharing with a purchasing firm their books, right? Their P&Ls, their billing practices, and that's when the work in progress typically comes up. The work in progress for billable hour firms can certainly be very easily measured in terms of, okay, how much billing are we doing? How often are we billing? Which is typically monthly. And then when a sale could happen and we're negotiating an agreement and then signing an agreement, typically there's a portion in the agreement that speaks to how do we deal with not only that work in progress, but the accounts receivables. And often both of them accrue towards the seller. That is, the seller gets credit for the work in progress that's collected by the buyer, and any accounts receivables that are owed to a seller are typically paid out and received by that seller. Where the negotiations can get a little more complicated is when there are flat fees, okay, which happens a lot in estate planning. And we look at how much of a flat fee, and whether that's also estate planning, criminal law, immigration law, different practice areas where there are flat fees. So that becomes negotiated. And then also when it comes to contingency-based firms, okay, what happens in a contingency matter, let's say in a personal injury law matter, when that type of firm is being sold, there the measurement is not so much work in progress, but quantum merit, and it just is always negotiated between, again, looking at the 6 meetings needed to sell a law practice, between meetings 2 through 5. We're looking at it during due diligence. We're negotiating a letter of intent. We sign a letter of intent, and then we negotiate an actual agreement. Among those meetings, there's a lot of number crunching, a lot of disclosures, and then there's negotiations on what those terms are when it comes to that work in progress and the accounts receivables. And it definitely is all covered during those meetings between the initial meet and greet and actually signing an agreement. So, Elizabeth, thank you so much for that question.